more than a few of them recuse, then we need to figure that out and may need to present the whole situation to the Ethics Commission for a rule of necessity opinion. But in general, understand that there are situations where you must recuse. There are situations where you may recuse. Friendships are not regulated by the Code of Ethics. That's one question we get a lot. And maybe it's, you have to recuse when any property that you or your family members own is within the notice area. Even if you don't live there, even if the family member doesn't live there. Let's say you have a sister who owns property within the notice area for a particular application. There's a per se rule, there's a presumption that anything affecting the property that requires zoning or planning approval could have an impact on property value. You might say, well, if anything, this is going to lower property value, but it doesn't work like that. You have to recuse anyway when family members are involved. So any questions about what family members or business associates, see me with questions. Former business associates, again, you're not required to recuse, but if it's a recurring relationship, contact me and we'll talk through it. Really, the question you can ask yourself that works, I would say, in 90% of the situations is, would I feel comfortable having all the facts about this situation, reported in the local media? Because generally, if it feels right, it's probably not a situation where you need to recuse, but if it's something that you think, well, this is too close for comfort, that's a good signal that recusal might be required. You also can't appear before the board. If any of you own property and and Joe has experience with this, if any of you own property or family members and have an application before the board, we need to seek a hardship exemption from the Ethics Commission, and our office can assist you with that. And the other thing you should know in general is that if there are any questions related to the Code of Ethics where you need an advisory opinion, our office can certainly assist. The general rule, and you'll find this if you read the Code of Ethics or even, the website, is you've got to participate and make decisions fairly and independently. If, for example, any of you feel that your private work, work you do in your private capacity, would somehow impair your judgment, give me a call and let's talk about that, because sometimes there are situations that come up where I might say, in this case, I'd prefer to have you sit this one out. The other thing you should know is that in situations where you're required to recuse, you can't simply have someone else, like appearances before your own board. You can't say, well, I'll just have my surveyor or my engineer present the application. That still counts as a personal appearance. That appearance can be imputed to you. Any kind of general questions about the Code of Ethics before we move on to the substantive land use stuff? Okay. So now I'll go back to the agenda and the general overview of the permitting process. And I apologize for those of you who've been on the board for many years. This is a kind of basic level training, so this is not going to be new information for some of you. The statute that governs, I think, 95% of what we as a planning board do here is called the Development Review Act. It's Title 45, Chapter 23 of the Rhode Island General Laws. So that governs procedure and review requirements, required findings for subdivisions and land development projects. And as you know, for major projects, there's 3 review stages, right? There's master, preliminary, and final. Really, pre-application is a stage all by itself, but for purposes of tonight's discussion, let's focus on master, prelim, and final. Minor projects have two-stage review, preliminary and final. So for a subdivision or a land development project, master plan is intended to be a broad conceptual outline of the development. And I'll read from the definition here in the statute. The master plan is defined as an overall plan for a proposed project site outlining general rather than detailed development intentions. It describes the basic parameters of a major development proposal rather than giving full engineering details required in major land development or major subdivision review. And then the reference statute on master plan review also gives us some insight into what master plan review is. So in the first section of that statute, submission requirements, the key word here is information. So requirements for the master plan and supporting material for this phase of review include but are not limited to information on the natural and built features of the surrounding neighborhood, existing natural and man-made conditions of the development site, including topographic features, the freshwater, wetland, and coastal zone boundaries, the floodplains, as well as the proposed design concept, proposed public improvements and dedications, tentative construction phasing, and potential neighborhood impacts. And the final provision for that statute regarding vesting also gives us some insights into what master plan approval gets you at the end. When you pass that stage of review, what are you left with? Master plan vesting includes the zoning requirements, conceptual layout, and all conditions shown on the approved master plan drawings and supporting materials. So then, in a very general sense, the master plan review stage can be summarized as the applicant presents information to the board on the general concept of the development proposal. Overall layout, number of units, right, density, general configuration, those are all things that once reviewed and approved and the plan is stamped, the developer is considered vested with that master plan approval. That means, and its initial 2-year vesting period with 2 by right 1-year extensions for a total of 4 years. That means that if the planning board approves a master plan application and the town council the following month amends the zoning ordinance such that the application currently approved would no longer conforms to the zoning ordinance, that developer is vested to proceed according to the approved master plan under the zoning requirements in effect at the time of approval. The idea is that the town shouldn't be able to change the rules of the game or pull out the rug from under the developer at that point in the process. And even that concept extends to when an application is submitted and certified complete. At that point, once an application is certified complete, the planning board must review it in accordance with the zoning ordinance and subdivision regulations in effect at the time of certification of completeness. That prevents the town from getting an application that you know, if there's a neighborhood outcry, the council says, well, we'll just change the rules. It doesn't work like that. The key distinction between the master plan stage and the preliminary plan stage is the level of, the kind and I think probably quantity of evidence that the developer needs to put forward before the planning board to gain an approval. Because instead of that word information, the preliminary plan submission requirements specifically state that including but not limited to engineering plans depicting the existing site conditions, engineering plans depicting the proposed development project, a perimeter survey, all permits required by state or federal agencies prior to commencement of construction. And I'll skip the last part of that just explains what permits are needed. So there's a real difference between master plan and preliminary plan. Master plan, the developer has a general green light to proceed. The idea being you're vested to proceed with the master plan based on, you know, the approved plan, but only if the engineering that is produced for the next stage of review shows that the site can support, you know, if it's a 50-unit proposed project, can the site support 50 units? Will you get your DEM permits? You know, and sometimes, in many cases, you'll see a development knocked back in size by the developer. So maybe the vested master plan approval was for 50 units. Now the preliminary application comes to staff desks. It's been revised down to 40. That's because the engineers have figured out it doesn't work on the site. So preliminary plan stage of review needs to be more detailed and thorough, and you can and should require, you know, engineering plans versus just general statements. I think in practice you do see engineering plans at a master plan application. You know, developers know they're going to have to do these kind of plans anyway, so many of them, and sometimes you'll see combined review stages, so master plan and preliminary plan stages can be combined. The developer says, I'll wait to come to the board for my master plan approval until I have everything I need for preliminary as well, and then rather than having to come twice, it's just one time. It might take a little longer, but a little more efficient permitting process. So again, you have a 4-year vesting period, 2 years by right, with the right to extend for 2 one-year extensions. Final plan stage of review is really making sure all the I's are dotted and T's are crossed. Final can be delegated to the administrative officer, or it can be done by the board. That's on a case-by-case basis. Important to note that appeals can be taken either by an applicant if they're denied, or by objectors if the project is approved at each stage of review, master plan and preliminary plan, except that appeals from final plan approval are limited to issues that really weren't discussed at preliminary plan stage. So the other point I want to make that's important regarding your role as town officials is if decisions of this board are appealed, they go to the zoning board. So let's say you deny an application for a major land development project. That must go to the zoning board as an intermediate review stage before it's taken to Superior Court. I think the thinking is, let's let another local decision maker kind of have a second look at it before it goes to court. The zoning board may affirm the decision, may reverse the decision. If it goes to Superior Court, sometimes developers will say, not only do we want the judge to reverse the decision, but we want the town to pay our attorney's fees. That's happened several years ago. The Jamestown Zoning Board made a decision, I think, denying a dimensional variance application, and they were ordered to pay, I think it was somewhere in the neighborhood of $20,000. It was upward of tens of thousands in attorney's fees for the applicant. The key is that the town, the planning board, the decisions have to be substantially justified, and that's a goal that I think universally we work toward in South Kingstown, right? So a judge on review may find reversible error for whatever reason in one of your decisions. Maybe there just wasn't enough evidence on a certain point. We read the standards wrong, we misapplied them, but as long as they're substantially justified, we're insulated from any kind of claims of attorney's fees. But that's kind of the key. Of course, you want the developments in the community to look good, but always keep that in the back of your mind too, that the decisions need to be made. The decisions that you're making do need to be substantially justified and able to be defended in court. I want to just touch on something that's not an option in South Kingstown at this point, but I want you to be aware of it, and some of you are, I know. A process called Unified Development Review was enabled by the General Assembly a few years ago, and some towns and cities have enabled it in their zoning ordinances. You know that now, except for comprehensive permits, which we're going to talk about later when we get to affordable housing, developers have to go to both the planning board and the zoning board if the project requires zoning relief. The planning board is permitted to grant certain adjustments, right? Like the zoning ordinance specifies, flexible frontage provisions. There are certain provisions that the board can tweak without requiring the applicant to take a trip to the zoning board. But in many cases, whether it's use relief or dimensional relief, you'll see an application come before you where the next stop is the zoning board. There's an option for the applicant to take a path known as Unified Development Review only if the council has enabled it in its zoning ordinance. That allows one-stop shopping before the planning board. So in those municipalities that have that as an option, the planning board can also grant zoning relief, variances, and special use permits. That's not an now. Again, I just want you to be aware of it. The other kinds of applications that you see in addition to land development projects and subdivision applications are applications for development plan review. That's also called site plan review. And there's two types of development plan review applications that will come before you. And one is for uses that are permitted by right under the zoning ordinance. So in those cases, the council has determined that certain uses don't need any relief, meaning don't need a public hearing before the zoning board, but that a reviewing body, the planning board, should review the application and determine that it meets all the criteria set forth in the zoning ordinance and subdivision regulations for whatever the development plan review requirements are for that use. In those cases, your decision is final. In other cases, you'll be undertaking advisory development plan review. That's review that is advisory to the zoning board. So in those cases, you're really just making a recommendation, and the zoning board, whether it's a special use permit application or some other relief, will be making the ultimate decision. In some cases, you may even see an applicant come before you who requires a zoning amendment and or a comprehensive plan amendment. And some applicants say, well, why can't I go to the council first? Because if they're not going to give me the green light, why, waste the time before the planning board? The idea, and the law says in Rhode Island, you need to get conditional approval for the first review stage from the planning board first and an advisory recommendation to the council on the zoning ordinance amendment. That way the council has something to go on other than what the applicant says when it considers whether it's appropriate to amend the zoning ordinance or comp plan for that proposed use. Then the applicant would come back to the planning board for the next review stages.
Amy, could you
Yes.
just go back for a second to the extensions and explain the process once an applicant with an approved plan has gone beyond the 4 years?
Yeah, so the vesting period again is when the planning board issues an approval, it's good, it's valid for 2 years initially from the date of recording, right? Not the date of the meeting, the date of recording. After that point, the applicant needs to submit a letter to the administrative officer indicating their request for an extension. And those are considered by right. They don't need to make any showing. They just need to exercise their right to have that approval extended. After that point, they do need to show cause. I should say the applicant also needs to appear before the planning board, but And you can ask questions. You can ask questions about, well, why haven't you moved forward? You know, I consider it a by right extension, so you can certainly ask the questions, but we can't deny them. So if they have a master plan approval and the clock is ticking, then they have to submit the next application. So the master plan approval doesn't expire before, you know, they have to submit the preliminary application before the master plan application expires. Otherwise, they got to go back to square one with the pre-application, and the zoning ordinance may have changed in the interim or seek reinstatement under the subregs. Right, exactly. So after that initial 4 years, the statute says vesting may be extended for a longer period for good cause shown if requested by the applicant in writing and approved by the planning board. So after the 4 years, an applicant needs to show good cause for the extension. We're a few years past the recession, but there was a statute that for several years told all those expiration periods pertaining to zoning and planning approvals, known as the tolling statute. It was enacted in 2009, and it expired, I want to say 2017, maybe 2018. From between those time frames, the clock was not ticking on land use approvals. So then after, you know, the tolling statute expired, we did get a lot of calls. All the towns got lots of calls from neighbors saying, what's going on? I never heard of, you know, I never got notice of any hearing. It was developers proceeding on their vested plans that had been, vested approvals that had been told by the tolling statute. I don't know if any of them are still kind of within that time frame. They may be. So anything approved during the effective date of the tolling statute is potentially still in effect if they've gotten extensions. Now, if a project does expire, meaning if the applicant doesn't move forward and that clock runs out, they can seek reinstatement rather than starting from square one, and that's dealt with in our subdivision regulations, and there are certain findings that the board has to make with respect to reinstatement. While we're on the subdivision regulations, we can discuss changes to approved plans. In many cases, a developer will need to tweak some aspect of an approved plan, and it may be along the way or it may be after the permitting process is concluded, but you know, the development isn't quite finished. In that case, the administrative officer has to determine whether the change is a major change or a minor change. If it's a major change, the planning board has to essentially review it as if it were a preliminary plan application, has to hold a public hearing. If it's a minor change, meaning in general, is it consistent with the intent of the original approval, that can be approved administratively. Yes. Yep.
The regulations. No, that's correct.
Plugged in now. With regards to the extension, two aspects associated with it. If it's, to Amy's point, if it's an extension, that applicant is submitting correspondence or, in essence, proof in their request that they feel that there have been no regulatory changes or conditions that affects their development as originally approved. For instance, you know, say someone had a shopping center approved and it's in its third year and they're coming in for a 1-year extension. If it's still the same zoning, if it's still the same dimensional requirements, if you haven't adopted any architectural standards, all the conditions associated with that original approval haven't changed. So in that scenario, in all aspects, the approval should be extended. If, for instance, someone asks for an extension and you've adopted new regulations, you have to decide as a commission whether they're doing that for legitimate reasons with regards to the extension. To Amy's point on a reinstatement, I think you're less likely, if your regulations have changed, to reinstate a previously approved project that may be subject to new regulations.
Right, that's
Yes.
the 4-year vesting period.
So I'll give you, if someone applied today and we deem that application complete and tomorrow you adopted, we're talking about architectural and design standards tonight. If you adopted architectural and design standards, tomorrow, that application would be reviewed under the current regulations when it was deemed complete, and that would be without architectural or design guidelines. They were vested when they were deemed complete to be evaluated under existing regulations as of that date.
That's not a statutory requirement. So this gives me an opportunity to make a general point that our actions, and the zoning board chair will say this every meeting, we can't just make a decision because we think it's a good decision. We're constrained 100% by the statute. So our guiding documents are the statute, the subdivision regulations. The subdivision regulations flesh out what the board is permitted to do under the statute. If there's a requirement in our subdivision regulations that doesn't flow from some provision of the Development Review Act that I can pinpoint to, it's considered ultra vires or outside our legal authority to require. So, to your point, changing site conditions is not a permissible reason to deny an extension request. In the initial 4 years vesting period, that's 2 + 1 + 1, there's no permissible legal reason I'm advising you for denying an extension, because the next sentence of the statute indicates that thereafter the developer can request that approval to be extended for good cause shown. There's nothing below good cause. So after that 4-year period, then the developer needs to show good cause. And maybe the planning board says, well, wait a minute, I don't think we have good cause to extend this for reasons X, Y, Z, which may include changing site conditions, changing neighborhood conditions, changing ordinance and regulatory provisions. But in that initial 4-year period, they are permitted to proceed with that approval. Yes? That they get an approval that's initially valid for 2 years, then they can come back for a 1-year extension and a second 1-year extension, totaling 4. So a couple weeks ago, an applicant who had an approved preliminary plan application wanted to skip a step and get a 2-year extension, and I advise we can't do that. It's eventually going to be allowed if they come back next year, that not having, proceeded, but we have to do 2 + 1 + 1. Yeah.
Just point out that the extensions have to be timely requested. You have to submit that request for extension before your original 2-year approval expires. If you allow that 2-year approval to expire, now you're into reinstatement already and you've lost your right.
Yeah, good point. Thank you. And I think the key dates are, the date of recording of the original approval and the date the request was made. So if the request is made and then the planning board doesn't meet for another week, I think that's okay. Of course, an applicant who likes some breathing room will make sure that doesn't happen. They'll come in a month early versus a week late. But yes, as long as the request for an extension was received by staff before the original approval expires, it's considered timely. Are we ready, I think, to move on to affordable housing? Okay, because that's another big topic. Affordable housing deserves some special attention, and Josh, I know you can educate us on this as well. There's a few different types of affordable housing regulations to review, and one is inclusionary zoning. In Rhode Island, some but not all municipalities, including South Kingstown, have inclusionary zoning ordinance provisions, meaning that developments above a certain threshold must set aside a certain proportion of the development, the dwelling units, as deed-restricted affordable housing. And in South Kingstown, it's what, 4 or 5? 6, thank you. Okay, so if you submit a 5-unit development, you're not subject to inclusionary zoning, but if you're building more than 6 dwelling units, 20% of the dwelling units need to be set aside as deed-restricted affordable housing. In exchange, state law mandates that the applicant get some kind of incentive, meaning a density bonus. So in exchange for giving us, the town, some affordable housing, we'll let you, the developer, build more dwelling units than you would otherwise be allowed to on this plot of land. Affordable housing units, as you know, many of you know, help us get closer to that 10% aspirational goal that the General Assembly sets. And the significance of the 10% goal comes into play with comprehensive permits. I mean, of course, it's also important for market conditions and the crazy market that we're in now. But so that's type number 1. Developments that have 20% of dwelling units set aside as deed-restricted affordable housing. Sometimes developers will say, rather than doing 20%, if I bump that up to 25%, I'm now in the comprehensive permit category. Comprehensive permits are a special type of application where the state has forced the planning board to look at the development application with a real focus through the lens of affordable housing. So the normal focus of the board is, what's good for the site, what's good for the neighborhood. With comprehensive permits, the normal standards that apply to the application are replaced by a set of standards that forces the planning board to balance the state and local need for affordable housing against whatever relief is required. So, and the incentive for the developer deed restricting 25% or more of the development to as affordable housing is one-stop shopping. There's no need to go to the zoning board for dimensional relief, meaning, lot area per dwelling unit. You can, maybe the yield plan would show that the site could, a conventional yield plan would say this site would be appropriate for 4 houses. They come in with a proposal to put 12 dwelling units on site. That's allowed. And they don't need to satisfy the standards that would normally apply for a dimensional variance or a special use permit, right? More than a mere inconvenience, the standards that apply are specifically set forth in the LMI Housing Act. Comprehensive permits are also subject to special appellate procedure. If the planning board denies a comprehensive permit application, it doesn't go to the zoning board. The appeal goes to SHAB, the State Housing Appeals Board, if that's taken by a developer. And SHAB then looks at whether the town has an approved affordable housing plan. That's within our comprehensive plan, which, as you know, is now state approved. We're good for 10 years. So SK now has a state-approved affordable housing plan until at least 2031. So then SHAB can't simply say, well, we think we know what's best, what's reasonable and consistent with local needs. SHAB is bound by our comprehensive plan and specifically the affordable housing provisions contained within it. Towns that don't have approved affordable housing plans, SHAB is permitted under state law to determine whether the proposal is reasonable and consistent with local needs. And the lack of specificity in that phrase from the statute means that SHAB has a lot of discretion when reviewing projects, and more often than not, I don't have the statistics at my fingertips, but I can tell you based on my experience and, reviewing their past decisions, SHAB does great work. It's a statutory board that is designed to go to SHAB. More often than not, they will be reversed on appeal. That's why in many cases, of course, each application is different. They all are judged on their unique merits with the unique conditions and what's before you in the record from the neighbors, from the experts, your own knowledge of the area. But in general, I'd prefer to see an approval with conditions than a flat-out denial, because if the Housing Appeals Board reverses a denial, there may or may not be any conditions on SHAB's approval. Of course, they'd have to go forward to the next review stage, but, in general, I know South Kingstown is very supportive of encouraging affordable housing, so all things being equal, I prefer to see applications move forward as approvals with conditions.
Amy, can you further define what deed restricted is and the mechanism that allows for it, and also AMI and the role of the monitoring agencies?
Yeah, there are a couple of different definitions in various statutes, but essentially a deed restriction is a legal document that gets recorded that binds, that runs with the property, right? It's not specific to the occupant or developer. Well, it may be specific to the occupant, but it says this property may only be used as affordable housing. In the case of a for sale unit, the purchase price is limited. In the case of a rental unit, the rental price may fluctuate, but it's tied to area median income. So in certain cases, and rental units are limited to, I want to say 80% of area median income. For sale dwelling units may be available to households earning as much as 120% of area median income. So, I think the common perception of the term affordable housing is like low income or Section 8. This is not Section 8, and that's a whole different program, and in most cases it's not even really low income housing. I mean, there are projects in other municipalities where, they're capped at 50 or 40% of area median income. 120% of area median income to me is like workforce housing. So the deed restriction is recorded in the land evidence records. It allows the town or Rhode Island Housing or the monitoring agent to take enforcement action against the developer or, a subsequent owner if the property is used in violation of that deed restriction. The developer has to pay a yearly monitoring fee to a community agency, the monitoring agent, and that covers the monitoring agency's costs of ensuring that transfers of this property comply with the deed restriction. And what happens is transfers, a new deed restriction is recorded. In some cases, the clock is even restarted. It's run by the town, it's run by our office, making sure that everything is in order. The deed restrictions may be for as short as 30 years, maybe for 99 years. And again, I know of at least one monitoring agency that restarts the clock whenever a new either tenant or purchaser comes in. So the deed restriction is the legal means by which we can ensure that the property is actually used for affordable housing. On the books, any property that has a deed restriction counts towards our quota of affordable housing. In practice, we obviously want to see that those properties are actually being utilized and aren't just sitting vacant. It doesn't really help the town to have, 50 units vacant. It helps the town to have those units occupied with, people who can live in them. Yes. Okay. Okay. As far as the period of the deed restriction, the LMI Housing Act says it has to be at least 30 years. Well, I think the phrasing of the statute says for 99 years or any other time period that the town and the developer agree to, but in no event less than 30 years, right? The typical term of a mortgage. As far as AMI, I've got to reference another statute there for that, but that is an area where under state law, the towns are given some authority to prescribe exactly what they want. Yeah.
Conditions of approval are really important.
Yeah, even if they seem redundant, it's important to have those findings of fact, as we have learned. And I have to say, in recent years, there have been more applicants come forward initially with the 80% AMI to start with, which is a positive thing.
And Susan, thanks. I had a moment to find that provision, which is in a different section of the general laws, and it defines affordable housing differently for rental units and for sale units. So it says in the case of dwelling units for sale, housing that is affordable means housing in which principal, interest, taxes, which may be adjusted by state and local programs for property tax relief, and insurance constitute no more than 30% of the gross household income for a household with less than 120% of AMI adjusted for family size. In the case of dwelling units for rent, housing that is affordable means housing for which the rent, heat, and utilities other than telephone constitute no more than 30% of the gross annual household income for a household with 80% or less of AMI adjusted for family size. So there is some room within state law for the towns to require as conditions of approval. I mean, if it's all driven by what's in our affordable housing plan, if our comprehensive plan says the critical need is low-income housing, then when developers submit applications, we can try to get them to steer more toward the lower end of that range. I think Josh knows more than I do about that one. Okay. Yeah. Yeah. It's driven by the actual household, the actual applicant. So when there's, and I don't know the mechanics myself of how the monitoring agencies what their process is for turnover and getting new people in, but it's based on whether the actual household, whatever their income is compared to area median income. So it's not, the bedroom size isn't what's important, it's about the household that's going to be living there.
I believe there's a formula.
Yeah. So, Madam Chair, I think I can address that. Susan, to your point in question, the unit has a value, and the person who's proposing to occupy that unit has to meet an income standard, and it's a threshold. You just need to be below it. So we'll just use a number. If a medium income or medium income for affordability is $70,000 for a 3-bedroom unit, and that qualifies for a rent of $1,200 a month. If someone only makes $30,000 a year, that rent is not adjusted to that income. That unit bears a price of $1,200. So it meets a threshold for affordability, but it doesn't go on affordability of the applicant proposing to occupy the unit. So it's not a sliding scale. It just says the unit being brought to market will meet the 80th percentile of medium income for the area, and that rent will be X. Okay. So again, what it means is, someone only making $30,000 may not be able to afford that unit. Someone has to be at or near that 80 percentile income rate, 30% of their adjusted gross for net to use on housing. But again, it's not a sliding scale. So if someone applies and makes $70,000 and someone applies who makes 40, even though both people can afford the 1,200, actually, it doesn't get adjusted for the lower income.
And Rhode Island Housing does have a number of formulas that they use for different things, amongst which I hope Amy will speak about in a little bit, is the fee in lieu of.
I can move on to that now, unless we've got any more questions. Okay. Yeah.
Maybe single families, rentals, larger houses, and smaller houses as part of this affordable housing. In the past, the board has been very consistent that affordable housing piece has to be represented in the market. Basically, the same numbers, the same price. So he has 20 houses in the building, kind of big, kind of small, but we want that affordable housing. Put that percentage to be of the big and of the small, the same percentage as the we've been very consistent, and that does come up with a lot of times the developer wants to buy big houses that he can sell, small houses as affordable housing, so that's something that will come up quite often.
Okay. Moving on to fee in lieu. This goes back to the inclusionary zoning statute. So now we've moved away from comprehensive permit applications. In 2014, the General Assembly made a significant amendment to the inclusionary zoning statute. Before 2014, some municipalities, at least a few of them, had allowed developers to a few different choices when it came to inclusionary zoning. The default choice, the expected choice, was the LMI units are located on site. They're within the proposed development. Sometimes developers and planning boards agreed this site maybe is not appropriate for LMI housing, maybe it's too far from a bus route, maybe the site simply can't support any more units. So we'll let you put the LMI units somewhere else in town. That's off-site development. Another option was dedication of land to the town. The developers also had an option in some towns of submitting a fee to the town in lieu of actual development of LMI housing units. Cutting a check to the town, saying, town, now you have the money, you create these LMI units using, your own affordable housing commission and your own kind of infrastructure. The Rhode Island Supreme Court then reviewed, in reviewing a case involving fees in lieu of development, said cities and towns don't have the authority to require or even allow fees in lieu of development. So that 2014 amendment was in response to a court case. So now towns have specific authority to allow that. But I want to read from the statute because the way the statute is phrased is particularly important. And this is subsection B on the inclusionary zoning statute, which is 4524-46.1, and that's in the Zoning Enabling Act. A zoning ordinance that includes inclusionary zoning may provide that the affordable housing must be built on site or utilize one or more alternative methods of production, including but not limited to off-site construction or rehabilitation, donation of land suitable for development of the required affordable units, and or the payment of a fee in lieu of the construction or provision of affordable housing units. For all projects subject to inclusionary zoning, density bonuses and other incentives shall be established by the community and shall apply to offset differential costs of below-market units. The next subsection reads, this fee in lieu of the construction or provision of affordable housing shall be the choice of the developer or builder applied on a per-unit basis. And I'm going to eliminate the rest of the statute because the significant portion is what I just read, shall be the choice of the developer. So in 2014, when this statutory change took effect, we advised South Kingstown that if we have a fee in lieu provision in our zoning ordinance, we, the planning board, can't say, well, on this project, we don't want a fee in lieu. We want you to put the units, the LMI units, right on site. The General Assembly, in using that terminology, shall be the choice of the developer or builder, means that now developers have the choice whether they want to construct on-site, off-site, donate land, or submit a fee in lieu. But that's only, that's if all those options are authorized in our zoning ordinance. So we did have a fee in lieu provision. I don't think it's effective anymore. I think it has lapsed. And I think it lapsed because the council, upon, receiving that advice, thought, well, we don't like the idea that it's going to be the developer's choice, because the previous zoning ordinance that we had, the previous provision pertaining to fee in lieu that predated that 2014 amendment, said it's the planning board's choice. We'll decide, with each application, how the LMI units get constructed. The other significant amendment in that, the other significant change in that 2014 amendment is that there's now a formula that Rhode Island Housing, releases a table every year, and they have whatever the per unit fee is. And I think when the first one came out, everybody thought it was, pretty low. I don't know, I can't recall off the top of my head what it is or was for South Kingstown, but
40,000, it's ridiculous.
yeah, much lower than you would expect.
And there is an interest in changing both the criteria for the fee in lieu so that it is based on the desire of the community, and the contorted formula that they use to come up with this price per lot. And if you look at, there's a table, and if you look at it, it's not based on anything that we would normally consider relevant. I mean, the fees are all over the place, and some of the communities with the highest real estate prices have a very low dollar amount for the fee in lieu. In addition to that, there's language in there that if the fee is paid to, whether it's a nonprofit or, for example, our Affordable Housing Collaborative, that fee must be used within 2 years.
Right? Yeah.
So if a community was trying to build up some money and they didn't have any fee in lieu of dollars until, say, a 10-year time period, the money would go back to Rhode Island Housing. Not fair. So that's one of the things that some folks are working to change. No. Because of that provision whereby the developer makes the choice rather than the town.
But it can still be on site?
Yes.
Yeah, the on-site density can be greater than what it was. It's really the bottom line number, right? Market rate plus affordable rates, whatever that final X number is, has to be greater than what they could build by right under zoning. Otherwise, it's not considered a density bonus. The state says, towns, cities and towns, we don't want you to just require affordable housing. That's a hardship to developers. We want the developers to get something on the other side of the equation to offset these costs. We don't want them losing money. And in some cases, you have developers coming back to the board asking for changes to the approved plans, or indicating to the board they've had difficulty in marketing the LMI units. Yeah, the bottom line number of how many units is contained within the project, whether it's off-site or on-site, there has to be a density bonus in there somewhere. And they're going to take the density bonus on them, but they're not going to build more off-site LMI units than, they're going to build the bare minimum, right? They're going to pack in more market rate units to maximize that density bonus for the main, development site. Are there other questions on affordable housing? Because if not, I think I want to kind of wrap up with a point about wetlands. Our office has a memo in process on this, so you'll be getting kind of the rough draft narrative version tonight. Some of you may recall that in 2015, the General Assembly enacted legislation that directed the DEM and Coastal Resources Management Council to promulgate regulations pertaining to wetlands, setbacks, and buffer zones. So the legislation said until those regulations are adopted, cities and towns can enforce existing ordinance provisions, pertaining to wetlands setbacks. So in the zoning ordinance, there's a special use permit required for an OWTS, a septic system, within a certain distance of a wetland. We see those applications frequently. The law said that from the point of enactment, so after the law was effective in 2015, cities or towns could no longer adopt stricter regulations pertaining to wetlands, setbacks, and buffers. They could enforce what was on the books, but couldn't adopt stricter regulations. The most important part of the legislation is the effect of the regulations. The law said that once the regulations were promulgated, cities and towns would no longer have the authority to regulate development within a certain distance of wetland areas. That would be solely within the purview of either the DEM or CRMC, depending on what type of wetland area we're talking about. Those regulations, I want to say, were initially supposed to be promulgated by 2017, and then the General Assembly maybe gave an extra 18 months, and then at some point the statute wasn't amended anymore because it became clear that it was going to take much longer than originally intended. So after a long regulatory process, which I know Maria was involved in, the regulations have finally been published, and they're effective, is it January 1st? 2022. So the regs are out. I haven't yet had a chance to review them. I'm going to send those along with a memo, and I know there's an explanation also from DEM and CRMC on what the regulations do and don't do. But the main point is that we have significantly limited local authority now and expanded the state's authority with regard to development in the area of wetlands. I think it doesn't change the fact that when you have development proposed within close proximity to wetlands, someone still needs to review that application. The only thing that's changed is now, instead of a local decision maker, meaning the zoning board or potentially the planning board, it's now in the hands of the state authority that normally has permitting authority over wetlands, right? That's the DEM normally issues wetlands permits and OWTS permits. So in a sense, it's a more efficient permitting process. I still need to review and give you a little more specific advice on how this affects the planning board's regulatory authority, because it doesn't change at all the our authority with regard to general, one of the required findings, right, is no negative effects on the environment. The law didn't change that, right? That's not written out. But we do need to be careful, and I think it probably constrains the zoning board's authority more so than it does the planning board's authority, but we're going to need to take a close look at the regs and comb through it and see where wetlands areas are mentioned, because there may be provisions or certain sections that we have to cross out.
I think one of the aspects is Conservation Commission looks at on-site septic. That's in closer proximity to what the state would look at. So whether the new legislation trumps that, that's to not give the regulatory authority to the Conservation Commission, DEM, at that regulatory agency. So that's one of the areas I think that may affect South Kingstown.
And another thing was that, at least in South Kingstown, there was a division between A and B types of wetlands, which would have a different level of protection. So rather than giving South Kingstown the greatest degree of protection, which would have been A, we were designated Part A and Part B, which was a subject of conversation. I don't know, Paul, you have more insight on that.
No, I don't want to weigh on this at all.
And I know that I'll be interested, Amy, to hear your take on the municipal petition process, which was somewhat burdensome in at least the last version.
Yeah, so I'll be giving fuller advice on that once I have a chance to read it all through. I think that's probably it as far as prepared content. I don't know if there's anything else we want to go over with regard to Zoom or in person, if we want to touch on any Open Meetings Act. I mean, I might as well talk about some kind of key points on Open Meetings Act while you're all here and for the benefit of the new members, although I know you're not new to Open Meetings Act from the affordable housing, but no emailing everyone. That's considered a violation of the Open Meetings Act, right? The Zoom rule is gone now. The executive order expired, so that's what the Zoom rule did. It suspended those provisions, barring electronic or telephonic communication. Scheduling emails are permitted. The chair, any other member can email and say, I can't make it, or can we set up a special meeting? No emailing everyone with substantive questions, thoughts. You can email staff. You can email legal counsel. Now, technically the rule applies to a quorum, so is it legally permissible for one member to email another member? Maybe, but how do I know that two members aren't emailing separately and then other two members, and at some point it becomes a quorum, right? So our advice to avoid any open meetings issues is any discussion amongst you all on matters within your purview should be taking place at duly noticed public meetings where there's an opportunity for citizen input, or at least, an open, on-the-record discussion. So you can certainly pose any questions to staff. Staff can relay questions to the applicant. There's nothing wrong with that. There's no prohibition against contacting staff or legal counsel, but collective discussions on email especially, but phone too, text, we've got to avoid that.
Social events,
So,
town holiday party.
yeah, town holiday party, I don't think we post that on open, as on the Secretary of State, although they do post the Newport St. Patrick's Day Parade as a council meeting. But, yeah, the general rule is, like, we've done, training sessions before, we've done community charrettes, and if we expect, or if we say, well, maybe a quorum of the council, quorum of the planning board will be there, it's better to post it as an open meeting. If it's a social event, no issue. However, I would say probably don't all sit at the same table, because there's an issue of public perception, right? Somebody thinks, well, they must all be talking about my application. And, the allegation can be made, maybe without any support, but crazier complaints have been made. We don't want to be in the, we'd prefer not to be defending Open Meetings Act complaints. Yeah, so social events are in a different category, a wedding that you're all invited to, but trainings, just contact our office with any questions. Staff is at the top of their game with regard to open meetings. Keep in mind, for your own information, just so you can kind of get a sense of what the rules are, we do have to post agendas within 48 or no later than 48 hours before the meeting, excluding weekends and holidays. So until a few years ago, weekends and holidays counted. Now they don't. So you won't see Monday night council meetings posted on Fridays anymore. They're posted on Thursdays or sooner. Sometimes meeting agendas are posted in advance. More often than not, they're posted kind of toward the end of that deadline. Our meeting agendas are different because our applications, many of them have statutory notice provisions. So either the notice has gone out or it hasn't. And so the agenda may be set, but not quite posted. If you have any questions about what's coming up, just contact staff. Yeah, the big advice I have on open meetings, though, is don't email each other or text, phone meetings. Another question that comes up is site visits, and we've talked about this. What can I, as a planning board member, do? I can't say you can trespass because it's not allowed. You're certainly allowed to do drive-bys. If you see someone on the site, you can go on there with their permission. I can't recall if our application has something in there now that they acknowledge that the site may be visited.
I think there's a general understanding.
Yeah.
I know there's some more national case law out there that if an applicant said, I'm applying, but I'm not going to let you walk, it's a 10-lot subdivision, I'm not going to let you walk the property. There's some case law that supports a denial because you couldn't walk the property and, in essence, do your job. But 30-plus years, I've potentially only had one landowner in 30-plus years who had issues, and it was primarily when it came down to it, related to unannounced visits. So they wanted advance notice on the property.
Yeah, so tying in with the Open Meetings Act, don't conduct joint visits unless we're calling it a public meeting, a site visit that's open to the public. So visit a property, do a drive-by on your own time. You all know, I'm sure, that there's a lot you can do now with aerial photography and even, comparing different years to see how, conditions change, wetlands contracting or expanding. You will hear time and again, more often than not, it will be objectors who will request a site visit. Come see the neighborhood. You could, in theory, do a site visit on every application. You have 2 meetings a month regularly. You have special meetings occasionally. Site visits, I think, should really be limited to, are there particular conditions that really can't be shown any other way than you physically being out on the site? They do have to be open to the public. It's difficult. We have to manage it because we can't have a few people off in a corner conversing. We can't say, well, the public can't go to a certain portion. So I like to see site visits used sparingly. I also think that there's a lot that can be done now with, videos, potentially drone, flyovers. So it's just something to think about.
In the past, when we have had site visits and we have had neighbors show up, we have made it very clear to them that they can't engage with the board, that we can't have conversations with them, we can't answer questions. If they have questions or concerns, that those need to be handled at the meeting. So the site visits have worked out very well. We just haven't had a lot of them.
Yeah, so another kind of potpourri topic I'll touch on very briefly is the time limits. Some of you may know that the time limits for our review of applications, so the deadlines for the planning board to act on applications were shortened a few years ago. So developers made the, successful pitch to the General Assembly, our projects are taking too long to go through the approval process. Deadlines are very important because the state law says if the plan isn't, if we don't make a decision within that deadline, the plan is considered approved as submitted. So the choices for us are act within the deadline or ask the developer to agree to an extension of the deadline. So that's totally permissible, and you've seen that. At some point, the developer may say, we've kind of given it our best shot, we want an up or down, and that's within their right. But I just want you to be aware that we do have shortened review deadlines now. And I don't know whether there's any, I know there's been a movement to kind of extend those a little bit more, but hasn't gotten traction yet.
Sorry, Robin, I didn't hear the question.
95 days is the limit from the time that the application is considered complete, right?
They're for determining whether application is complete?
So after it's been determined complete, the planning board has to make a decision within 95 days.
It varies based on the application. Whether it's,
That's not how the pamphlet reads.
Yeah, that pamphlet, I don't know if it was updated in the last couple of years, so we'll take a look at that. And I should also mention, every year our office will issue a memo to advise you and the council and staff. And I think probably some of you have already seen the memo from statewide planning that does essentially the same thing. So be on the lookout for a memo from our office that highlights the bills related to land use that were enacted this legislative session.
yep. And Robin, we can put together a more concise list for you, because again, some of the applications you see are advisory to zoning, which don't have those tight time frames, versus major, minor land use applications.
Yeah, so on the pamphlet on the town site, for major and minor, it reads the board has to act in 95 days.
We'll take a look at that. Amy, just one other reminder to planning board members, and I'll preface this by saying you've all been pretty good. And this isn't as a reminder of something you've done that needs correcting, but with regards to Open Meeting Act, and in essence, in Rhode Island, the request for information, just remember, if you send an email to staff, when you hit that enter button, that send button, send means forever. So be cautious in your written words, whether you're posing a question or stating opinion. If you're uncomfortable having someone read the email that you send staff, call us.
Good point.
Put it in an email, and the applicant asks for it, or a neighbor opposition group, or just anyone in general asks for all copies of all digital correspondence associated with a particular application, we have to provide that to them. And I preface that comment by, my experience in this community is the planning board members and our other land use boards have been pretty good with regards to that. So I haven't mentioned it, early on in my tenure here, but it's just a reminder, we do have some board members. We all can be extremely opinionated in our views based on our background and feelings about certain developments. Again, feel free to call. We can vet the questions. We can try and get answers for you. But again, once you hit send, send does mean forever. And it's something I remind staff of also. You know,
Oh, and Housing Works RI publishes a housing fact book on a regular basis. It's amazing the amount of information that's contained in there. Totally worth getting a copy. It's called Housing Works RI.
Picking up on what Jamie said, an important topic I should note is due process and social media. So some of you may be on social media. That's another thing where, you know, what you put out there is forever. Don't comment on any applications that are before you. That goes without saying. Even applications that haven't officially come in yet but could come in, you don't want to be, you know, an applicant can hold it up and say, well, you're biased, you should recuse. So that's a due process argument. Also, like, if one board member posts something and a few of you like it, that could lead to an open meetings violation. So let's, you know, being friends is great, maybe not friend each other on social media, or at least scroll to view versus interact. So with regard to due process, the most important, you know, the element of due process, right, notice and an opportunity to be heard and fundamental fairness. People might come up to you in the grocery store and want to talk about applications, and you have to say, I'd love to hear your thoughts, but I want the whole board to hear them. Please come to a meeting. If you can't come, submit your comments in advance to staff. It's tough to say that, but they have to understand, you know, as much as you'd like to, I'm sure we all have our views on what comes before the board. No conversations, you know, regarding applications that are before you, unless it's here during a meeting. Yeah. 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 I sympathize. Yeah. Yeah. You could say something general. That's fine. I'm okay with, you know, your opinion, posting something like, your opinion is important. We encourage you to come to a meeting to, you know, review the evidence. Post the link to the planning department's website where all the documents live. I think we're going to keep that up, right? I don't think that's going away now that we're back to in-person meetings. So now there's really, other than, you know, general time, when people come in and have misinformation, it's, you know, you have all the application materials in front of you available to review. It's, you know, so posting something general like that, I'm okay with. Posting something specific, I'd say stay away from. And I think maybe you've all seen the media reports about that, the medical marijuana lottery for the new dispensary is being delayed. So we don't, under the current state of the law with the medical marijuana dispensaries, the additional ones that were approved, I think, is it 2 years ago now? 2019? Yeah, so, right, because there will be one in, I don't know if South County is the right term, it was maybe 7 towns, and South Kingstown was one of them. So we don't know if there will be any in South Kingstown yet, and we're probably not going to know until sometime next year with the lottery being delayed. And I've been told, right, that in the fall, the General Assembly's coming back with some grand bargain on the recreational marijuana, so we'll have to see what happens, and there may or may not be some kind of municipal opt-out referendum. We'll just have to see what happens.
Thanks, Amy.
Sure.
Other questions for Amy? I'm sure there'll be more
Yeah.
in the future. All right, Jamie, architecture and design.
Maria, it is 8:30, and I know you usually take a quick break at 9. Do you want to potentially take a quick break, and then
Okay with
I'll try and keep it to 30, 35 minutes?
Sounds good,
or
thanks.
so?
Tapping your feet really fast.
Maria, we all set?
Set? Yes.
Okay.
All right, Jamie has a presentation for us on architecture and design.
I want to start off by thanking Amy for her presentation tonight. I think it was very worthwhile. I want to say this may be a little more fun than talking about the law for an hour and a half. But feel free to, I don't want to say boo and hiss as you see certain slides, but the general discussion, and I've talked to Maria about this as the chair. Part of it is talking about a continued conversation about the missing middle, but also part of it is looking a little more into the future with regards to the discussion of developing design standards and architectural guidelines for the community as it relates to develop multi-household unit developments, whether it be multiple single-family homes as part of a cottage-type development, or duplex, mansion homes, triplex, fourplex, townhouse, stack flats, and larger apartment complexes. There's no initial intent to develop design or architectural standards for a single-family home on a standalone lot. That is really up to the individual, those individuals' tastes, likes, and dislikes. With regards to this is really intended for a discussion of things beyond the single-family house on a single lot. So mostly planned communities, larger developments, and things beyond duplexes and beyond. Some of the architecture and designs you'll see are from around the country. They're not necessarily all New England based. I have a variety of slides and architectural styles to understand and try and get a handle on what South Kingstown means to you as a board member from a visual and also design standpoint. So again, first slide, typically, again, discussion with the planning board on design and architecture. Really looking at the social, economic activity, and those two components equal community vitality. You're really trying to use design standards and architectural standards to represent what South Kingstown is about and what you want South Kingstown to be about as development occurs in the future. The second aspect of that is just, a continued discussion on the missing middle aspect of everything that we've worked towards with the cottage regulations and have moved forward on. Horsley Witten is still working on certain aspects of the plan. Jeff Davis had a family matter to attend to and was out of the office for a few weeks, if not a little bit longer. So we've hit the pause button a little bit on that. But again, at the staff level, we're continuing the discussion. Just a quick discussion on why we plan, why planners plan, why planning board members are members of a board that plans, why the town has a comprehensive community plan. A lot of it is we want to live and work in a community that brings out the best of ourselves and the people that are around us. So much of the real estate industry is extractive, and what we mean is out-of-town investors or out-of-region investors mine the value of your community and potentially take that value and bring it back to where they live and don't initially invest it back into the community as a local developer does. So one of the questions that's always kind of posed to planning board members as you look at the regulatory process is, can you create a real estate model or a regulatory model where you can encourage local people to invest in their own neighborhoods and create a process that creates new life and value that benefits the community that you live in? It's kind of a overriding principle, something that would exist in a perfect world if a perfect world existed. My wife reminds me it does not, even though I think I live in it. But how do you generate the local community to be the development team and not necessarily just leave it to the outside, almost hedge fund group backed entities to tell you what is best for you and your community. A lot of that is hinged on the discussion about what kinds of places you like to live in, what are the built environments that you like to visit, how do you feel and what is the perception of those areas and the maintenance of those areas. I'm sure you've gone to some communities outside of South Kingstown that you feel are beautiful. Why do you feel they're beautiful? Is it the architecture? Is it the maintenance? Is it the aesthetics of the community? And not just the aesthetics of the building, but the aesthetics of the placemaking, because it's engaged, it's active. There are people on the street. There are outside restaurants. There are things to look at outside of just that built environment. Is it a place that you can sit and have a cup of coffee for an hour and be engaged by what's the street activity? And again, that discussion starts with trying to describe places you love to live in. And you're all residents of South Kingstown, so the assumption is you're here because you love South Kingstown and you're really proud of your community. So how do we, again, try to articulate that? How do we try to strengthen neighborhoods through small-scale real estate projects? And really have the conversation that everything doesn't have to be done at a massive scale. You can do this incrementally, at small scale with infill. You don't have to wait for that one large real estate investor to save you in one large project in town. Some of those standards, and we'll post this on our webpage tomorrow, but really looking at high standards that are achievable and they represent community aspirations. We're looking for new residents. New units equate new neighbors. They may not be neighbors that exist in South Kingston. They may be people who aspire to live within the community of South Kingston. Right now it's difficult to do that because your new unit creation is minimal. Looking at how do those new residents contribute value. New residents contribute value both socially and economically, and that leads to vitality of a community. Within that, you have neighborhood value. It takes kind of a family to create a neighborhood. Neighborhood creates community, and community creates a sense of place. Those neighborhoods are typically done in collaboration, and those neighborhoods need to be well thought out and designed kind of outside the realm of that traditional, 1,200-foot long cul-de-sac with 8 houses on it that people just drive to and may or may not over time get to know their neighbors. Again, community-based, of the community, by the community, for the community. And in that perfect world that I like to say I live in, there's a mix of transportation options, be it walking, biking, mass transit, or access to other transportation within the region. You're fortunate that you're close to an international airport, you're close to Amtrak, and you're even closer to 2 larger regional airports, being New York and Boston. Along with that is trying to develop a vision. When you develop that vision, is it clear or does the vision vary? You're a board of 7 people. There are 6 of you here tonight. You may not all agree all the time. You may not agree with staff. Staff may not agree with you. And I think those conversations are healthy and they're necessary. Going back to the missing middle real quickly, I had discussed this slide with Maria Mack as the chairperson, and this is representative of the types of housing. I think one fault of this that Maria and I have discussed is it doesn't fairly represent scale. So if you move from the left to a cottage, that townhouse doesn't look much bigger than the cottage. And again, this is intended to show you the progression of housing, not necessarily the progression of scale. And I played around with trying to make it more representative of scale, but I think I was trying to do too much and lose focus on what this slide is meant to represent. The slide, the section below the housing is really kind of some of the commercial or economic discussions with regards to, if you looked at Missing Middle, how do you look at Missing Middle for commercial? You know, does someone who wants to be a restaurateur start in a tent to a food truck to a trailer to then a small part of retail to that small retail or small restaurant to potentially multiple restaurants or a larger restaurant in a larger facility? And again, these are really intended for discussion purposes. Some of the discussion we've had is residential infill associated with cottage development. You just adopted the cottage regulations. Town council approved those a little over a month ago, so those are being incorporated into our zoning ordinance and are effective. As you look at the cottage, a shotgun house, which is typically a narrow and longer house, isn't potentially within the vernacular of South Kingstown. What you typically have is a cottage with an L. So it has a squarer or more rectangular footprint, not a long and narrow. But as you do infill, you may look at something because of a narrow lot. To squeeze those 2 units in, you may look at a longer, narrower, which is typically referred to as a shotgun house with 2 more traditional cottages behind it and then the parking behind that. And again, we're just kind of building on that vernacular. The first one is a single story. The second one shows, in essence, a development of a duplex on a 2-story footprint. These represent first floor rental units, second floor rental unit with internal stairs. Here there are a total of 6 units with garages in the back and an alley entry. And I would say the house on the right probably represents more South Kingstown versus the house with the dual porch, which is more reminiscent of maybe South Carolina or the Carolinas, even going over into Louisiana and Mississippi. The second photo is just a continued discussion again of the next step, or looking at a fourplex and how a fourplex can be incorporated on a site with cottage developments. And I think a lot of the discussions we had is, I understand the architecture of an individual unit, but how does the architecture of a unit with additional units work on a site? Here you're looking at 2 fourplexes or 8 units on the front of the property, 4 additional units to the rear with a total of 12 parking spaces, and you're looking at a lot size of just under a half an acre, 18,000 square feet. So with the right lot, with the right configuration, with the right access to it, you can fit those 12 units on literally a half an acre with sewer and water. Just a quick little look at adapted reuse. There aren't too many buildings like this, but there are a few within the community. And again, it's looking at a building and understanding its vision. A really good architect, just simple sketch, pen and ink, can show the vision of a building there. Adding a little color adds a little dimension. Another representative photo where you had an old 7-bay garage storage that could easily be switched to retail, restaurant, office space, or again, it could be residential housing. Just adding a little bit of color to that one. Looking at housing choice, I think that's something that's important and is also integral to the town of South Kingstown. Looking at variety of housing types, fee simple, small format, attached and detached, variety on smaller lots, layout and frontage flexibilities, with a variety of mobility options. We talked about that in the perfect world if every house had access to transit, was walkable to services, and had other options with regards to bike and rail. Also, these places should be in proximity to goods. The right developments belong in the right places, and you also need to support a variety of people. One of the things we talked about is these special places, and we always see these wonderful designs. Who really designs them? And I think South Kingston's been fairly fortunate that you've had a lot of good architects, you've had a lot of good designers, and you've even had some good builders who moved to the design and architectural side, and you have developers. But what you also have those examples in town of that builder who may have gotten a set of plans off the internet that may or may not be your vision long-term for the community. A colonial that's 2,200 square feet that proportionally plays well, that someone puts on a Xerox copier and blows it up to 3,600 square feet, you may lose those proportions, and I'm sure you can drive around town and see examples of, that was really nice when it was in the 18 to 2,200 square foot, but boy, when they did it at 4,000 square feet, the dormers don't work anymore, the roof pitches don't work anymore. Why'd they put the garage doors facing the street versus on the side? So there are other design towns. I think as real estate becomes more valuable in town and your design standards become clearer in town, you'll see a transition more to the architect, designer, builder, developer, landscape mix versus just the builder taking a set of plans off the internet. So again, potentially with that you'll get better design. Because without good design, you can potentially get things that look like this from the air. Now, this is a very walkable community. It plays very well from the street. But an interesting thing that I use this slide is that, according to the National Home Builders Association, 1.4 homes were built by home builders in 2020, yet only 2% were designed by architects. So, and we had the discussion that architectural standards aren't necessarily meant for the one house on the individual lot, but this photograph was obviously designed by an engineer, a land planner, and I would hope there were some aspects to that to bring good suburban, rural, urban design to this.
Jamie, where is that?
That is in California. And again, your planning director is not proposing this scale or density for South Kingstown. But it's an example of, even though someone may use that design team, if you don't clearly articulate your vision from a design standpoint and regulatory standpoint, this could be 100% code compliant. So, along with that is just, development contact. What do developers occasionally miss? They occasionally miss that their styles are repetitive, unwalkable, automobile dependent, and private realm focused. So in essence, almost gated. We're trying to kind of change the dynamics of the discussion. Excuse me? Oh yeah, you can boo. And again, I appreciate the feedback. It's understanding that none of these slides are intended to scare you. It's just understanding that sometimes well-intended regulations on a piece of land with sewer and water have unintended consequences. So you need to be careful what you wish for, both from a regulatory standpoint. So for me, as your planning director, this is the beginning of a discussion to understand what the palette is for the planning board representing the community.
Jamie, I think the issue with a lot of these is the monotony. I mean, these could be really nice homes. I had the opportunity to spend a week in Dean Estates recently looking after my dad's house, and it's a lovely place to walk. The lawns are perfect and everybody has a gardener, but it's monotonous. You can sort of walk around from one street to the next and get lost.
Yes.
Whereas, you look at High Street, there's a lot happening.
And that goes back to that slide about development engaging the community, that there's street activation, that there's, on High Street, there's traffic, but that traffic negates vitality and street interaction, even if you're sitting on your front porch, that there's motion. But a lot of the developments intend to be, and I'll bring this down back to a more human scale. Again, this is a planned unit development. On its face value, the density looks fairly significant, but some of the aspects of this is it's 100% geothermal. It's got 51% green space. It has 15 miles of paths. It has 8 acres of Central Park and 19 parks in total. And again, this is a couple 100-acre development. But they're incorporating certain things. And what's interesting here is the mix, that you have 750 single-family homes, 600 multifamily. There's actually a hotel. There's retail associated with it. Probably one of the things that's difficult is when you have that retail at that scale, it's really hard to incorporate 270,000 square feet of retail into the community versus kind of having it stand alone. I think here, if they scaled the retail down, they potentially could have done more of that traditional downtown Main Street aspect to this type of development. I think they did a nice job. If you look at, I don't have a pointer, but if you look at the offset way photograph, and if you took out a component of that, there are components within this slide that I think are extremely well done. I don't think it interrelates to the commercial development that well.
What is an activated sidewalk and street?
The activation of the sidewalk is it's event-based, or there are aspects associated with that it's active versus passive. So there may be vendors that are allowed. There may be restaurant space within the sidewalk. So it's activated. It's active versus, for some aspects, if you go to the North End in Boston, and with their closing of Hanover and allowing people to be outside now in that street parking spot, that is more active than, in essence, the sidewalk on High Street. I would say Main Street has a more activative streetscape and system versus High Street.
And experiential retail? What does that mean?
If we go back to that missing middle slide where you have the pop-up tent and the so there's the ability to have kind of those one-offs. There may be someone who's a student at RISD who wants to stick their toe in the water with regards to fashion but doesn't want retail space, but there's flex space within that community for a pop-up tent or pop-up shop to allow someone to enter the marketplace and test the waters without having to enter into a 12-month lease and have a $36,000 gross leasable area, not for the 12-month period. And again, we can get into more of this. And again, back to more of the human scale of placemaking in the cottage core. And the key part of this between the prior slide and this slide is you have to make those decisions as the planning board in concert with town council with regards to legislative action. You get to decide. This isn't your planning director or planning staff telling you what South Kingston should look like. This is an open discussion of you being able to articulate visually of what your aspirations are for the community. Okay.
And yeah, and Jamie, I was going to say something about this too. A lot of it is about context. I mean, you see a nice range of architectural styles. In the background, behind the houses, it looks like a canopy of trees, as though it's adjacent to a forest. At the top of the drawing, you see the leafy canopy above. You see a rectangular area of open green space, and then you see lots of vegetation between all of the houses. And then in the foreground, it looks like some kind of like a brick path, and again, shaded by those trees from above. So contextually, it gives a different perception than if you just saw a clear-cut lot in the middle of, wherever.
I absolutely agree with you and appreciate the comments. And what's difficult is, some of these samples that we look at, and Maria has a book in front of her called The Missing Middle, which was done by Union Studios for the Cape Cod Commission. You're looking at some of the best designers not in a region, but in the country. And it's that ability in that early discussion of how do you turn the builder of a single-family home into a developer who hires the landscape architect, who has the toolbox along with an architectural or design firm to bring that to your community, either from the regulatory side or just that discussion side. This is a newer development that's in the Midwest. It's a slight change and variation from that traditional cottage development that Maria had just mentioned in the prior slide. But a lot of this is also thoughtful design. There is a common theme and style. There's architectural detail associated with these houses, and there's a mix of housing types between hiding duplexes within this photo to single family to kind of the stack flat, and within this community there's also family compounds. Different than the normal architecture that you would see here. Again, it's a modern interpretation of that New England vernacular or Midwestern vernacular. It's not quite Seattle and Redland or the Northwest Pacific, but again, it's different than South Kingstown. But this is a newer, well-planned out community. And within that development, simple things of just changing the style of a doorway, that it's not just a doorway, behind that door someone lives there. And there's that interaction and that activity. I mentioned within that development there was a family compound. This is a unique that this is actually 5 buildings, and it's designed as a family compound to, in essence, house extended family. Now, the vernacular without the discussion of making it South Kingstown-like, I thought it was a unique take on designing a family compound in a more downtown-type suburban urban setting. And if you look at this closely, you have the activation of the central court, of that common shared space. You also have good interaction and with the street, so it doesn't play as a large set of buildings if you were on the sidewalk.
Something about that, can you just go back there for a second? I don't know if it's the height of the buildings relative to the houses in the background, but I think military barracks, when I look at that.
I think it's the 412 roofs. If you wanted to change that to New England, you take that second story and you add a 612 or an 812 pitched roof, and you knock that down and add a couple of dormers. The field stone walls, that's not representative of many homes in the community. But again, I thought it was unique, and you'll see in the next couple slides that these are building blocks. We'll move into the next slide. And it's really just building with components. You can change those components to meet the architectural vernacular that you want to discuss and portray. So again, here's a simple, kind of center hall colonial where you can add multiple additions to change what that building will look like. So you could have that representative of colonial, federal, Georgian, depending on how you put those components together. Another example of that is more of the townhouse look of a potential infill or new construction, always thinking in 3 dimensions. But again, that's a very basic block that you're just adding fenestration onto that primary block or your box to make it read better from the street. Along with that discussion is how it plays in the complex of a single townhouse or a single building to 4 and 6-plex. So again, that is that same building in that prior slide, just slightly modified to have it read different as a 4-plex. Snuck a little a play on duplexes. Over 30-plus years of building an architectural portfolio, what's interesting is I do not have many duplexes. Duplexes are always a challenge with regard to architecture, because you have that shared common wall or dead space between the two units. It usually affects window spacing. I thought this was a unique way to do this. Yeah.
This is really interesting, very nice way to do it.
Again, you know, if you talk about street activation, just those wider stairways, and again, if you added a little more porch there, you have enough room for that Adirondack chair or rocking chair on that porch. Have more street activation. Back to the building components again, and I went back to this slide just to show you that. Now, this is an articulation of kind of that more traditional townhouse colonial vibe, but there's always the modern interpretation of that. So you go from something that may be more prominent in New England to something that may be more prominent in the Pacific Northwest. And, you know, whether this is a thumbs up or a thumbs down, it's a discussion that I will guarantee I will have over the next few years with an architect who's looking at pushing that envelope on a modern interpretation of a historic vernacular. This is another take on looking at stepped components and the integration of three buildings, one being 1 story, one being 2, one being 3. And if you just look closely at this, you know, kind of ignore the southwestern El Paso style development or San Diego type development. But what's interesting about this is you incorporate all three of those buildings, and you also start to incorporate the components of a block. You start at 1 story, you go to 2 stories, and you go to 3 stories. It started out as 3 separate components, but you can build upon those 3 components. Again, you could reskin the buildings and make them read more New England or more SK. But again, I think this is an integral part of showing how 1 story, 2 stories, and 3 stories can play nicely together. Careful what you wish for. This is a 3-story, 6-unit building that I would say, if Susan's, yeah, and again, you know, part of the discussion is I don't want to just show you things that you're going to say, love it, love it, love it. That's what we want. You know, but potentially, if I had access to a good architect who could render quickly, I'm sure they could, in pen and ink, on tracing paper, make that much more acceptable to you from a palette perspective. This building, to me, if an architect showed me this in my office, I would say I'm not sure how the planning board's going to perceive this, but in all likelihood, it's not going to be favorable. Yeah. And again, we go back to the architects are working with these kind of blocks, and it's how you know, if you look at the top left here, that's the block they're working with. What type of fenestration do they add to it to make it read more South Kingstown?
And no amount of landscaping will help that one.
No.
It's not a bad building, it's just a bad thing.
It's not representative of what you're trying to articulate or achieve in the community. This is a modern play on historic vernacular. Again, I've turned off some of the animation, but if you look at that building in the top right, would anyone be surprised if I told you that building is only 13 feet wide? Buildings that you can do between 13 feet wide and 22 feet wide gives you the ultimate flexibility with regards to floor plan. A 22 feet wide with laminated beams right now, you can do almost anything without any structural walls on any of the floors. I think what's also interesting in this community, in this development, is we're used to the pitched roofs in most areas of town, but you do have some areas within the Main Street and even High Street area in Peacedale that, developers may want to look at utilizing that roof deck space. I think there are some amazing places in the downtown that if you had that outdoor third-story space could play really well. And one thing this photo is missing is that discussion, and I think, Paul, you touched upon it, is buildings look very different in a community in a photograph versus when you're actually on the street, and do they engage you on the one-story level? There's a discussion that, most taller buildings have a top, middle, and bottom, or base, and I think a lot of architecture in larger buildings loses that discussion of there's a top, there's a middle, and the base, and that bottom or base is designed to be human scaled, and the top either needs to add that fenestration or design to make it not look like, you can make an 8-story building read like a 3-story building. It's just the talent of the architecture. Again, another example within that same community showing 17-foot wide houses on 30 by 50 lots that actually have provisions of, because they're master planned, you give everyone usable outdoor space. In a traditional development, there'd be a lot line between those 3 houses, right? The lot on the house would have a common lot line, so one owner would have 5 feet, the next house would have 5 feet, and you can't do anything in a side yard in 5 feet. But if you master plan this and you give the house on the right ownership up into the wall of the house in the middle, they actually get usable, functional outdoor space. And that kind of goes in a domino effect down the block. And that's how you can kind of get away with a narrow house and still give them outdoor space without giving them, kind of the mindset is everybody wants front outdoor space or back outdoor space. And this development was unique in utilizing, spaces on the side of the buildings because there is no front or back to these homes. They face the alley on the back and the street on the front. Again, just looking at floor plans associated with this. Within this community, they have production elements. So, and again, I'm not saying that the architecture has any relationship to South Kingstown, but it's the same floor plan, just showing how that exterior building can be skinned 4 different ways. Potentially the top and bottom one, top being more traditional and bottom one being a modern interpretation of a traditional vernacular, but the 2 in the middle are probably more Scandinavian. Again, that's looking at that built environment and that vernacular on that streetscape. This is representative perhaps of a more modern interpretation of that historic pitched roof, cedar sided, although it's vertical versus horizontal. And again, these are things that may be borderline, thumbs up, thumbs down. Looking a little bit at the built environment, again, you have the potential over time in Lower Tower Hill for the redevelopment of those spaces. Again, this is just kind of showing the incremental blocks to potential redevelopment. 2-story, 3-story, and single-family, single-story buildings with a large building on the right. I don't want to say that may be representative of a large storage facility in your community, but at some point there may be development in front and to the side of that can mask a building like that. So I thought it was kind of unique that I found this one that had a building devoid of any kind of top, middle, bottom architecture. Again, back to the more human scale of a cottage-style development. What's unique on this is if you look at it quickly from that angle, they play as single-family homes, but these are all attached. So there's common space. You can kind of see the connections there. Again, simplicity is not the enemy. This architect believes in windows, doors for basic fenestration, and focus on what's viewed at the human scale. Again, good neighborhood fit, set and meet high expectations for new development. It equates to value within the community. A couple of sayings that came out of Congress for New Urbanism, that it's difficult to legislate good design. It's even more difficult to legislate out bad design. Focus on the street. Do not lose sight of what you can touch. It's right in front of you, and it's at that human scale. Within those buildings, that is the interior of that unit. Again, when you have that 18 to 22 foot wide floor plan, you can do a lot interior. So again, you can skin that building to be anything but provide a modern product to a potential buyer. And again, just adding a little bit color to that. This is a community, City of Bryan. It's in Texas. Again, there's no relationship between South Kingstown and Texas with regards to architecture, but this was a way that the community looked at cottage housing and basically having pre-approved designs that can play and meet different needs of the community. This place is a single family, small unit that's only 512 square feet. Here's a slightly larger version of that, which is 2-level, 3-bedroom, 3 baths. The next one is a 2-level, 3-bed, 3-bath. And again, it's just playing with those blocks. And then within these blocks, they can also play as a first floor unit and a second floor apartment, all fitting within that single family kind of vernacular or appearance. And you'll see in this slide that you have a first floor kitchen. And this is actually 3 units in this floor plan, where you have a front 2-bedroom unit, you have a 1-bedroom studio to the rear, and you have a 2-bedroom open floor plan on the second floor. But again, going back, it plays as a single family unit. Again, within that community, they were talking about flexible design. Again, the top right is more probably appropriate for South Kingston when you're talking about the architecture versus that kind of more southern Louisiana or row house within Providence of showing the 2 porches or decks. Option 1, option 2, the elevations for those, and then also looking at these. If you look closely on this next slide here, they're first floor apartments, second floor apartments. 2 bedrooms on the first floor, 1 bedroom on the second. And there's also an option for a 2-bedroom with a kitchenette on the second floor. So you can squeeze 3 units into that building. Changing the script a little bit and looking at a vernacular of a larger block or larger building that's in excess of 200 feet long, but potentially with street articulation as you're walking on the street plays a little more as single-family homes. Just adding a little color to that. Susan, maybe 2 on this one, but again, no, but we talk about, I had that slide that you can't legislate good design and you also can't legislate bad design. These are zoning codes from the 70s. The zoning code you have, in essence, is a product of the 60s and 70s, and it is devoid of design standards. So when you're just primarily looking at dimensional codes, you're subject to the marketplace or that builder who does a modern version of those buildings. Single family, that house on the left, single family development on a single lot. There are no architectural standards, there are no landscape standards in most communities. And I'm not saying this community should have those standards for single family, single lot development.
The one on the right is reminiscent of commercial buildings not that far from South Kingstown.
You have a few commercial office buildings that look very similar to that apartment building on the right.
And apartments.
Yes. We'll put this online. So, Again, just taking that kind of discussion of the individual building and looking at it in a master plan community. This development was not built. It was done by New England Design and for Alan Pesch, Skip Hayward, and Bobby Hayward. Here you had, to the top left, a discussion about single-family, multifamily, up to 4 units around a common traditional town green. That town green is, in essence, was planned to be 4 acres, so it wasn't a faux town green that you couldn't. The take on that was you could go and actually, throw a frisbee, the baseball with your son, throw a football, the kids could play there. To the right, you had a little more denser development with a traditional Main Street that was supposed to be incorporated in the 3-story. I think the bottom right, which is called Building E, is very reminiscent of the architecture and scale that you have on Main Street right in.
Yeah, exactly. That's what I was thinking. Some of those really skinny buildings that you showed us weren't particularly appealing, but if you put, not that those are all skinny, but if you put everything together, it is reminiscent of a Main Street. It looks like Newport. It looks like Bellevue Ave.
Right. And again, if you really look closely at this, there are only 3 building types. There's the 2 end units that just have different fenestration associated with them. The next 2 gable buildings are in essence identical except for the awnings at the street level activation, and then you have a flat roof in the middle. So an architect has a repetitive pattern, but playing with those patterns and intermixing them, it looks like a block. I always show this slide because to me it's interesting. On the slide on the left is probably more reminiscent of North Providence or East Providence, traditional 1950 through 1970 development on the right. But the cute part about this is they're both 11.7 units per acre. It's just 2 completely different ways to do it. One was in a built urban environment, and one was that suburban, traditional cul-de-sac. Again, adding color to that discussion of a redo potentially of certain areas as time moves on. This is, again, that discussion to Maria's point of, in essence, 5 smaller, narrower buildings, repeating the pattern, and then putting it on a block. These are 5 townhouses. These are under construction. They are all rentals. Within this development, there is another building that looks very similar to this, that instead of being townhouses, they're 3 stack flats. So there's a central common hallway that has apartment units on both the front face and the back face. When you have development like this and you're trying to relate to the street, which you're seeing that articulation, there's always a back of house. So you need to be conscientious of that, and that's the back of house to those townhouses. There again, you have a different view of that 5-unit townhouse, and behind it, where you can just see that gable, that's a stacked flat. So that's more of a traditional apartment type building, although it will read similar to the townhouses. That's what that development looks like. It's a planned unit development on 40 acres.
Way too many trees were cleared for that.
Excuse me?
Too many trees were cleared for that one.
That was actually built in a cornfield. So it's difficult. It's always unique because if I had an opportunity, if people are familiar with Celebrations, I had an opportunity to walk Celebrations during its design and just outside of Disney World. Again, it was designed by Disney, owned by Disney, and developed by a different group of conglomerates. But if you had the ability to look at it 15 plus years ago when it first started, and you had that 1.5 to 2 inch caliber tree that started, and then go back 15 years later, and see that 2 inch caliber tree reads very different. The difficulty here is, when you stick what you see there as an 1.5-inch caliber tree, porch roof covering, it really doesn't play well with a 3-story building. Developments like this are, you need to go back to them 20, 30 years from now. My experience would be, when Levittown was built on Long Island, reads very different from early photographs of, in essence, thousands of identical houses built just one after another after another. But if you go back and look at Levittown now, with 50-plus years of humanity, and also the homeowners who have added a dormer, added an L, taken the second floor off and gone up a second story, the street has a different lost some of that repetitive pattern. Again, this goes back to Milltown Commons, the ability to articulate a vision. Again, it takes a very special design team to articulate that. And again,
What's the building in the background on the left that looks like a barn? Is that a
was gonna be
residential?
designed as a community center.
Ah,
So this is part of the single-family unit and articulation around that central common green.
that's sort of a design that we have envisioned in some past commercial projects.
Catching a frisbee. And again, I know this architectural firm well. I know the owner very well, and depending on the communities in, with regards to the design, you also see the cars change.
And it's that.
The makes and models change with the community they're going in. Yes.
But the delineation of space is very interesting with the frame of the fence on the left, the sidewalk, then the planted strip. Then it looks like some parking spaces, sort of a bump out. Yeah, and so, it does have that traditional feel.
What was unique about this development, Maria, is when I was working in Connecticut and I was sent to a town for 2 years to look at this type of development style, I had the architectural firm actually asked, and the developers paid for kind of remote learning type aspects, where I took 2 of their architects to different sites within New England to study and evaluate aspects of different communities. We literally, on a tour, I took them to Mashpee Commons and literally picked it apart. Looked at, why did they do a street 24 feet wide with no activation to the street, with on-street parking that was literally kind of that modern cul-de-sac that is, the fire department wanted it 30 feet wide and wanted the 160-foot wide cul-de-sac, and there are certain aspects of developments like Mashpee or South County Commons or Levittown and others that you go to, and you really need to pick apart the why and why they did it. We also went up and looked at Red Mills in Norton, Massachusetts, and looked at why they did certain decisions there, and some decisions they made there, that there were 20-foot wide one-way streets with on-street parking. And you just, if you'd wonder why didn't you just do 16 feet wide? Well, the developer got tired of fighting with the local fire department who wanted everything to be 20 feet wide. So, a lot of designers will avoid one-way streets because the local fire or public safety wants 20 feet wide. So a lot of discussions about, 14-foot wide streets and angled parking fall by the wayside because of the discussion of I want 20 feet wide to get my biggest fire truck down there. Again, this was an articulation of what the main street would look like. This is another community. I mentioned Red Mill in Norton, Mass. If you look at the street articulation here, this is one of the properties we visited in the generation of Milltown. And again, that's an 8-unit building. It's about 240 feet long. It plays a little more as single family, but you really can't appreciate how that housing style and type relates to the street unless you're physically walking on the sidewalk. What's interesting in this community is they just undertook a $15 million bond and assessed that to the homeowners within the development to redo the siding and roofs after almost 20 years in development. 240 units shared that cost. And I may have misspoke. It may not be 15, may have been 5 million. It equates to like $50,000 a unit assessment. But again, even here, this development is about 10 years old, and this is a recent photo. You still don't have that street canopy yet. The good, the bad, and the indifferent. On the left side, a great example from Red Mill of how to hide your utilities. On the right, a less attractive example of how maybe not to do your utilities and not put them in a shed or add them to the architecture of the building. But that one is actually from Richmond. The photograph from the right is from Richmond, Rhode Island. The photo on the left is from Red Mill in Norton, Mass. Traditional, late 1800s, early 1900s development. I'll challenge anyone, Susan, you have to look at these slides, study, and tell me where these are. Okay. Again, those are in Newport. So, again, just to play on that with, if you take that photograph and you look at it and you just turn it into a watercolor, is that a look that may be more appropriate for South Kingstown or a modern interpretation of that? Yeah. You're getting close, Joe. You're getting close. Yeah, you're in the neighborhood. So, again, talking a little bit about the missing middle and that residential component, but I wanted to throw a few commercial aspects in here. I've had a lot of discussions over the years with corporate franchises and how they need to put the HVAC and the refrigeration unit at the back or within the roof system, but this was a development where we were able to articulate a vision through design standards, and you have a refrigeration unit and HVAC in that back unit. I think it plays for a commercial setting, plays well with the architecture of the building. Versus a lot of communities, you'll see decent architecture on the building, and then you'll see that prefabbed refrigeration unit plopped in the back. Again, just a few more slides back from Milltown. And again, looking at this, you have the single-family 2-unit, the downtown, and then looking at the actual articulation of the pedestrian passages. So there was a lot of level of detail that went through this. Four-family residential unit on the bottom right. Just again, visions and discussions about how to work within the community, and we looked at vernacular of that typical pedestrian passage, but we played off a real world and how that really works. And if people like that, if Susan gave that a thumbs up, how do you articulate in that in a design guideline? Again, that's just north of Bellevue in Newport. That's part of the town. It does but if you start the discussion early on with the developer with regards to expectations, they'll design around those standards. It may mean just beyond those trees that you're denser because you're giving up space to the public realm. That density isn't going to change. It's just where you put the density.
Well, with that kind of width, too, you could almost envision curb, grass strip, bike path, sidewalk.
Yeah. And again, I have examples from places around New England where, just beyond that are large 3- and 4-story office complexes. But as you drive down the street or you walk in there as a pedestrian, you don't feel overwhelmed by a 4-story building that may be 50 feet away from you because you're encapsulated in a different environment. I'll skip through Middletown a little bit. Again, just looking at, in essence, a pretty watercolor of a real building. So again, this is a box that someone added architectural detail to. It's a 2-story building. But again, it plays different from the street. Again, looking at a potential design community and how the street plays differently. There's a mix of kind of a grid pattern along with that curvilinear. If you look towards the top of the photograph where you can kind of see the infield for a ball field, those are elongated townhouses with backloaded garages. So those would be representative of the townhouse I showed you early on, with a mix of duplexes and single-family houses within the community. Again, another play on a watercolor for a real building. And again, are these thumbs ups or thumbs down? But I always have the discussion when an architect shows you a pretty rendering, the building never quite looks like the rendering, and good architecture can actually make the building look like the rendering that they promised you it would look like. Again, another play artistically on what someone tried to articulate as a building, what that building actually looks like, and adding color to that. That's from Georgetown in Washington. And again, the stone and the play on the stone may not be, if that was in Peacedale, maybe you could say that plays off the architectural vernacular nomenclature of Peacedale. But if I put that in Green Hill, that may not meet what's in Green Hill. Looking at more traditional, I've said I've always been challenged at looking at duplexes. This is a wonderfully done duplex from the 1700s in Newport, Rhode Island. I haven't been able to get a developer to do that, but there is a developer who used some of that architecture from this building and replicated it in a commercial building in Old Saybrook, Connecticut. That is a furniture store. Attached to that is a restaurant and a clothing store. And that's on the corner, in essence, of a Main and Main.
And that's sort of what, in certain parts of Newport, where you see those wider houses, and I think many of them have been turned into condos, and, the joke is the houses are so close to one another that you could reach out the window and touch the other one, but they work because of the architecture and the location.
Right. And this building is, if anyone was interested in that area, I'd encourage you to go to it. It's a very large building, but it really only works in combination of the fenestration associated with the rake, corner boards, the window treatments, the covered porches, the columns, and even though it doesn't look like a Lana landscaping, just that softness of the landscaping plays well there. And this is at in essence, a 4-way controlled intersection with 2 to 3 lanes in each direction. Again, just going back to details. And I'll go quickly through these slides. Again, architectural elevations of a building, the actual building. I'm going to challenge everybody. Again, this is basically, these are building components and blocks. You know, the architect started with just blocks and then started that articulation to a basically rectangular building. Right. And then if you look at this building, can anyone tell me what is in it? Okay. It's in essence medical office space. Or in essence a nonprofit social service agency that provides medical and social service.
So Jamie, there probably comes a point at which where you start with the basic building and then you add these components where there's probably a fine line between it becoming a hodgepodge versus
Yes.
elements that have been appropriately added.
And that's the talent aspect of the conversation I talked to about the architect, the designer, the builder, the landscape architect, that urban suburban design firm. You know, again, I'm showing you examples of some of the, you know, the better talent in New England and in the country. But again, if these are visions, we can articulate this through regulations.
Is part of the point that, when you think about it this way, I mean, this looks like an expensive building. Being more expensive than big blocks and floor space.
This building was designed on a budget, again, being a social service agency. But again, it has those block components. It's a rectangle that they added a faux covered walkway that serves functionality. That end unit building structure, that's actually where the bus comes in. It was designed as a bus stop.
Parking lot plants are too small.
The parking lot
The ones
plantings?
adjacent to that covered walkway.
Yeah. So.
Right.
And- You know, a well-done library. You know, these are bigger buildings. You know, a lot of times you'll look at these and you'll kind of wonder, there's a lot of roof here and roof line. But the first floor is probably done well enough that you don't see that roof line. Poorly done, I think you would just see roof. It's actually the color. Someone guessed market. This is a variation of that design by another architectural firm in Concord, Massachusetts, that actually did a market. Now, and with modern construction techniques, I'm just going to go through these quick. Come on. You have the ability to have internal space that looks like that. So from the outside, you know, this is basically a steel box with steel-clad siding that gives them that internal space. Versus someone through urban redevelopment built a building like this. They're in Newport. So, again, this was a dimensional code, not an architectural code. Just a quick example of well-done corporate architecture in a downtown setting that corporations will design to your standards if they find it financially viable to be within your community. And, you know, this is I will, full disclosure, this is in New Canaan, Connecticut. Extremely different price point than South Kingstown. So.
I'm surprised that, given that particular community, that it was not just the concrete, it's not concrete blocks, but the concrete wall. I'm surprised to see that versus it either being covered in some kind of
That's
material or
yeah.
stone.
It's interesting that you point that out, Maria. That is part of another project that was built in the 70s.
It's New Canaan, so the whole thing's a tear down.
So, but what's unique here is you have first floor commercial and you have second floor, and someone utilized that third floor residential space with outdoor component. New Canaan, Connecticut. Average single-family vacant house lot in New Canaan is about $1.2 million, whether it's a quarter acre or an acre. Glastonbury, Connecticut, just again, you're well aware of well-done, non-traditional corporate architecture. This is a unique building. Anyone want to tell me what this building is, or take a gander?
No windows.
It's a modern manufacturing facility that in this
There'd be windows.
yeah, in this rural community was designed to play off of a barn, a typical milking parlor. Yeah, if you look behind in the right, you can actually see the single floor building behind it. And then where the single floor component is an earthen berm that's landscape, has an evergreen hedge associated with it. We talked about celebrations, so I couldn't not have a slide from celebrations where that's storm drainage. Different way, again, different climate, different economic structure to that development. That's a picture from their downtown. And we talked about a development that occurs that doesn't have that mature tree yet. So this is 15 plus years after that tree was planted, where now that tree is, significantly higher than that 1.5-story elevation. So, full colors. I know you don't want your community to look like the photograph on the right, that you would appreciate your signage to look more like the photograph on the left. That's an assumption that I've made, but I think I'm not too far afield in that assumption. And again, back to that value and those standards. And I just have one more for you, if I can get to it. I do have one piece of homework for you. I disappeared. A little bit of a challenge and a little bit of homework. If as board members you could take 10 pictures of things that you feel represent South Kingstown, and then 10 pictures of what you feel doesn't represent South Kingstown, something that may have been done. I would call, we talked earlier about send means forever. So if you're not comfortable sending what you will be taking a picture of a property or a structure within your community that you may say you do not like. So if you're concerned about that, I would print them out and give them, drop them off at our office. But what I would like to do is, again, this helps me understand what your perspective is. To me, this is just the beginning of a conversation. Hopefully you appreciated it.
Do they have to be from South Kingston? I was thinking about those duplexes.
I think if we break the 10 into 5 and 5, in some aspects, your perception of what you like in town may be more representative by newer construction in a surrounding community of what you may like to see built in town. But again, if you broke it up into 5 and 5, 5 things that you don't like in a adjoining municipality that you wouldn't want replicated in your community, 5 things that you love or that you would like to see in your community. It's up to you. I mean, it's a discussion, it's a broad discussion. I showed you some of those commercial buildings, particularly the one that's that social service agency. That could easily be residential and apartment. It could be easily office, it could be medical, it could be a school. So. right, just bear with me. Oh, the road cross-section? It goes back to the discussion of land use regulations that come out of Euclidean zoning and in legislative powers. Amy touched upon, what your roles and responsibilities are. Your roles and responsibilities are a direct reflection of what the legislature in Rhode Island has allowed or given powers to you. There are a lot of communities throughout the state, given their land use legislation, have no ability to develop architectural standards. They have no ability to do that. Some of the places that you go to, if you look historically at Washington, D.C., Washington, D.C. looks the way it looks in some aspects because back in the 1700s, someone had a plan, both vertically and horizontally, of what that community should be like. I will guarantee you this community did not have architectural standards, and they had a signage regulation that was in all likelihood based off of the linear building frontage. A lot of older codes will say if you have a building that's 100 feet wide, you get 2 square feet for every linear foot of building frontage. And originally, they wrote that code when mom and pop stores were 20 feet wide, so they got a 40 square foot sign, which was 4 by 10. And then 1970 happened. And then all of a sudden, someone built a 200 foot wide store, and they got 400 square feet for a sign. And then they didn't have a height restriction. So, these are the poorest examples. Not intended to scare you, but again, your ability to regulate is a direct reflection of what Rhode Island gives you the authority to. Connecticut, through the 70s and 80s, and even into the early 90s, were just pushing the envelope of what they were allowed to do with regards to architectural standards. But places like Hilton Head have had architectural standards since the 60s. So it's a different discussion. You can't fault this community for this appearance. It's what was acceptable then. It may not be acceptable now.
And in addition to the lack of design standards, it's obviously just happened piecemeal. You have two-lane roads without any real division between the two.
Correct.
Some communities have transformed that kind of look, with some kind of median or planted medium, and using traffic calming, and it's probably also an example of a phrase that I've heard Brian use: commerce before community.
So again, the photo on the left is Evergreen Walk. It's in South Windsor, Connecticut. They developed design standards when they were looking at a planned unit development that was both commercial and residential. It was approved as residential and commercial. It's an outdoor lifestyle center, from LL Bean to an Apple store to your higher end retailers, and behind it was a residential component. They don't interact with each other. The commercial component existed for 15 plus years before a single residential unit was built.
Is that a giant street light?
Can you say that again,
Is
Maria?
that a giant street light next to that sign? Doesn't look like a tree because it's got
That is actually the stanchion pole for the intersection light control. And again, whether you're in Rhode Island, Massachusetts, or Connecticut, there's also a discussion with the Departments of Transportation of what color that infrastructure is. Whether it be black, some have done a dark Kelly green, and if you don't tell DOT or you don't have that design standard, that will look exactly what it is there today.
And the
But it-
trees have been removed, and they've named the street after a type of tree.
So. And just behind that sign is approximately 500 parking spaces, and you look at back of house. Again, it's that outdoor setting mall, so when you're in front of house, it plays very different than looking at the back of house. So it's designed as a faux main street with on-street parking, but there's over, I think, 1,500 parking spaces back of house. There's all the parking behind. Garden City is one of the earlier planned unit developments in the state of Rhode Island, if not the first, from my understanding. Garden City, when you're right in front of the stores, plays very different than when you're in the sea of parking. So again, my take tonight is the beginning of a conversation, and I appreciate your patience.
Just a couple immediate reactions. I know it's only the beginning of the conversation. One thing that struck me over and over again is you're talking about, leading with thinking about design and these elements that you're talking about, the fenestration, the way things play with the street, and then you played this sort of game a couple different times of what do you think this building is, and that's a really interesting thing to think about. When you lead with design, it opens up these other possibilities for use that we often think we need to zone and we need to plan with. Use goes over here. Dirty industrial manufacturing goes over here. But when you actually think about it, a lot of the ways that business has gone forward, commercial use is not what it used to be, right? And so there's lots of ways that you can revitalize main streets, downtowns with micro manufacturing, with artisan manufacturing, with advanced manufacturing in ways that make a really cool space as well, right? Like, increasingly it's very difficult working with small businesses to support a boutique retail business model on your main streets. And that's the only thing that people can imagine on their main streets a lot of times. It's an increasingly difficult business model to support. But people say, oh, I don't want manufacturing anywhere near my community because it's dirty, noisy, all these different things, resource intensive. Artisan manufacturing, maker spaces, things that do different things, and with the kind of stuff that you're talking about, how does it play with the street? How does it play with the design elements in a way that you wouldn't look at it and say, oh, that's dirty and ugly? You'd say, no, that fits right in, and it's actually vibrant, and it brings a lot of the things that you're talking about. So that really struck me in what you're talking about.
Josh, to your point, what's interesting, I put this slide back up. That building that I use as an example and have for 20 plus years was built in a community who was one of the last 3 towns in Connecticut who did not have zoning. And that building is existing non-conforming. Present zoning code does not allow that. That's zoned R80. So
One of the only things you showed us without windows, and all of the other ones had plenty of windows, and there was a proportionality between window height, width, which is what makes it.
this one was difficult because it's high-tech fiber optics manufacturing, so they needed the building height and they needed the controlled light and space.
Or if you had medical marijuana, there wouldn't be any windows either, probably.
So.
And because I'm not allowed to send you an email saying this, I'll say it in the public meeting. There's a little book about thinking about main streets and revitalizing them with small manufacturing. It's called Recast Your City by Ilana Preyos. So it's a really interesting little book and talks about that exact idea.
So we will post this presentation and slide deck on our webpage. We'll hopefully have it up tomorrow.
Thanks, Jamie. This was really helpful, and I think we all understand that we need to develop design standards as soon as possible, and this is a good first step. And the homework is interesting, too. Before we finish up, are there any comments from folks in terms of other activities that they want to bring up?
I would like to know more
we'll take that under advisement. We can, I'll work with the chair and potentially we can have that as a discussion with the town engineer, Rich Bourbonnais.
Any other updates from staff?
At 10:05 tonight, next meeting, Madam Chair.
All right, would someone like to make a motion to adjourn, even though we don't always have a motion to adjourn at work sessions? So moved. Second. All those in favor say aye. Motion carries. Thank you, everyone.